He had been gone for 5 years. Then the father appeared in court to defend his son. The boy had stopped looking at the door a long time ago. That was the thing nobody talks about when a parent leaves. Not the day they go, not the argument or the silence or the suitcase carried down the stairs at an hour when the house should have been quiet. Nobody talks about the specific moment, weeks or months later, when a child stops looking at the door, when the body gives up the reflex of hope before the mind has finished deciding to, when you stop turning your head at the sound of a car in the driveway or footsteps on the porch, and you do it so gradually and so quietly that one day you simply realize you have not looked at the door in a long time and you do not know exactly when you stopped. Ethan Calloway was 21 years old. He had stopped looking at the door when he was 16. He stood in Courtroom 3 of the Fulton County Superior Court in Atlanta, Georgia, in an orange detention jumpsuit with his hands folded in front of him and his head angled slightly down. Not in the posture of defeat exactly, though it looked like defeat from the gallery. It was the posture of someone who has been in a room like this before and has learned that the correct relationship to the proceedings is one of minimization. Make yourself small. Take up less space. Give the room less surface area to press against. He was 6 feet tall, and in the orange jumpsuit he looked smaller than that. The way people look smaller when they have decided that smallness is the safest available option. The charge was felony assault. The circumstances were contested. The version in the charging document described a fight outside a bar in Midtown Atlanta in which Ethan had struck another man hard enough to fracture his orbital bone. The version Ethan had told his public defender in 45 minutes together before the hearing was different. Not different in the facts of the physical event which had occurred, but different in the context that preceded it, which the charging document had reduced to the phrase a verbal altercation. The public defender assigned to his case was a 24-year-old named Jessica Tran, who was 9 months out of Emory Law School and carrying 27 active cases, and the specific exhaustion of someone who chose this work because they believed in it, and who is discovering month by month. That belief alone does not expand the hours in a day. She had done what she could. She had filed the motions, reviewed the witness statements, and prepared Ethan, as well as 45 minutes allows, for a proceeding of this weight. What she had not been able to find was the surveillance footage from the bar exterior camera that Ethan said would show what happened in the 3 minutes before the striking. The 3 minutes the charging document did not describe. The gallery held approximately 40 people. Ethan's mother, Dana Calloway, was in the second row. She was 44 years old and had raised Ethan and his younger sister alone since Ethan was 16, working as a hospital administrator in Decatur. And she sat with her hands clasped in her lap and her back perfectly straight in the posture of a woman who has decided that falling apart is not something she will do in this room, regardless of what happens in it. She had not told Ethan who else was coming. She had not been certain he would come until the night before, when she received a text that said only, "I will be there. 7:45. He arrived at 7:47. Nobody in the gallery recognized him at first. He was 61 years old, with white hair and a close-trimmed white beard, and he wore a dark suit that had been purchased for a different version of this moment. A better version, an earlier version, the version where he had not let 5 years pass before walking back through any door that mattered. He carried a leather briefcase worn at the corners in the way of something used seriously and often, and he moved through the courtroom with the deliberate and unhurried quality of someone who understood the geography of rooms like this one from the inside out. His name was Robert Calloway. He was a criminal defense attorney. He had been practicing for 31 years. He had tried cases in 14 states and argued before 3 federal circuit courts, and had, in the 5 years of his absence, built a reputation in constitutional criminal defense that several legal publications had described as one of the foremost in the country. He had been gone for 5 years. He took a seat at the defense table without explaining himself to Jessica Tran, who looked at him with the expression of someone who has been surprised in a professional context and is managing the surprise while maintaining the appearance of not being surprised. He placed the briefcase on the table. He opened it. He produced a legal pad, a pen, and a folder of documents that he set to the side with the practiced efficiency of someone arranging a workspace they have occupied 10,000 times. Then he looked at his son. Ethan had not turned when Robert sat down. He was looking at the front of the courtroom, at the empty bench, where Judge Patricia Harmon would appear in 11 minutes with the focused non-focus of someone managing their own nervous system through sustained will. Robert looked at him for a long moment. Then he said quietly, "Ethan." Ethan turned. The thing that crossed his face in the moment of recognition was not the thing you would expect from a story that wanted to be simple. It was not relief, not warmth, not the sudden softening of someone who has been carrying something heavy and has just been offered help with the weight. It was something more complicated and more honest, a combination of recognition and resistance, and something underneath both of them that had no clean name. The thing that lives in the space between needing someone and having spent years learning not to need them. He said, "What are you doing here?" It was not a question in the way he said it. Robert said, "I am here to represent you. I have a lawyer. I know. I have read her filings. She has done good work with the time she had." He did not look at Jessica Tran when he said this. "I have more time, and I found the footage." Ethan went still. Robert reached into the folder and produced a single printed still image. A frame capture from a surveillance camera, date-stamped, showing the exterior of the bar on the night in question. In the frame, 3 minutes before the moment described in the charging document, you could see clearly and without ambiguity a man with his hand at Ethan's collar and another man moving to flank him from the left. Ethan looked at the image for a long time. Then he looked at his father. Robert said, "But I've been working on this for 3 weeks, since your mother called me." A pause that carried the weight of everything the pause could not say. "I should have been working on it longer." The last 3 words landed in the space between them and stayed there. Jessica Tran said, "Mr. Calloway, are you licensed in Georgia?" "Ah, I am. Admitted to the Georgia bar in 2006, I have maintained the license." He produced his bar card and placed it on the table. "I would like to enter as co-counsel, with your permission and the court's. You remain lead attorney of record. I am here to supplement." She looked at the bar card. She looked at the footage still. She looked at the folder, which was visibly substantial. Not the folder of someone who had spent 3 weeks on a case, but the folder of someone who had spent 3 weeks working at the pace of someone with 31 years of experience and the specific motivation of a person with something to prove to themselves. "Okay," she said. Judge Patricia Harmon entered at 8:53. She was 57 years old and had been on the Fulton County bench for 14 years and had the particular quality of focused efficiency that develops in judges who have managed heavy dockets long enough that they have stopped performing efficiency and simply become it. She read the room the way experienced judges read rooms, quickly, completely, and with the specific attention that flags departures from expected configuration. She noted Robert Calloway at the defense table. His age and bearing and the briefcase and the manner in which he arranged his materials all communicated something specific to someone who had spent 14 years reading attorneys in her courtroom. "I see we have additional counsel for the defense. Please identify yourself for the record." Robert stood. "Robert Calloway, Your Honor, admitted to the Georgia bar, entering as co-counsel for the defendant." A pause. "Any relation to the defendant?" Another pause, shorter but audible to everyone in the room. His father, Robert said. The gallery did not make a sound, but the quality of its silence changed, from the routine silence of people waiting for proceedings to begin to the attentive silence of people who have understood that what they are attending is not routine. Dana Calloway in the second row looked at her hands. Judge Harmon looked at Robert for a moment with the expression of someone who has encountered something that does not fit a standard category and who has enough experience to know that the correct response is not to force it into one. "Proceed," she said. What no one in that courtroom understood yet was the full weight of what Robert Calloway had carried through the door with him. Not the briefcase, not the folder. The 5 years, the specific and irreversible 5 years of a man who left not because he did not love the people he was leaving, but because he had convinced himself, in the way that people with enough intelligence and enough pride sometimes convince themselves, that the work required of him could not be done from inside the life he had built. He had told himself it was temporary. He had told himself the distance was necessary. He had told himself many things in 5 years, and some of them had been partially true, and none of them had been completely true, and all of them together had added up to an absence that his son had felt in the specific way that absences feel when you are 16 and need your father, and your father is not there. He knew this. He had known it for 4 years of the 5. He had not known what to do with the knowing until Dana called him and told him what was happening, and something in her voice when she said it, some specific quality of a woman who has been carrying something alone for a very long time and is not asking for help but is also not hanging up, had made him understand that the time for deciding what to do with the knowing was over. He had been in Atlanta within 48 hours. He had hired the investigator within 72. He had worked for 3 weeks with the intensity of someone for whom the case was not a case. What Robert Calloway had built over those 3 weeks was not dramatic in presentation. It was the slower and more consequential work of someone who knows exactly what they are doing and does it completely, without waste. He found the surveillance footage through the private investigator. The footage came from a camera mounted on a commercial property across the street from the bar. Not the bar's own system, which the prosecution had reviewed, but a camera whose field of view included the relevant section of sidewalk at an angle the bar's cameras did not cover. He subpoenaed it on day 4. He had the chain of custody documentation in the folder. He presented the footage first. He walked Judge Harmon through the timestamp sequence with the methodical care of someone who understands that evidence is only as useful as its presentation is clear. The footage showed what Ethan had said it showed. 3 minutes before the moment described in the charging document, the man who later required medical attention had initiated the physical contact. The footage showed this without ambiguity. The prosecution objected on chain of custody grounds. Robert had the authentication documentation ready, the subpoena, the property owner's affidavit, the technical certification of the footage's integrity. The objection was overruled. He had also located 2 witnesses the original investigation had not interviewed. A couple who had been standing 20 feet from the incident and who had given their contact information to a bartender who had not passed it to the detective assigned to the case. The bartender had provided a written statement explaining this. Both witnesses testified to having seen the initial physical contact from the other party. Both maintained their accounts through cross-examination. He presented the medical records from the same night. Injuries documented at an urgent care facility that had not been included in the original investigative file. Contusions consistent with the physical account Ethan had given from the beginning. He presented a character history, not performed character witnesses seeking sympathy, but a documented record. 5 years of steady employment, no prior convictions, a letter from his employer describing him as reliable and trustworthy, a letter from the community organization where Ethan volunteered every Saturday morning, working with teenagers from his neighborhood. in the specific way of someone who understands from the inside what it costs a young person to have no one in their corner. He did not speak about being Ethan's father. He did not make the case personal in any register the court record would capture. He made the case legal, complete and precise, because that was what the case needed, and what it needed was what he owed. The prosecutor recalibrated 3 times during the hearing. Robert watched him recalibrate with the attention of someone who has spent 31 years watching prosecutors recalibrate, and who understands that the recalibration is its own form of information. By the time both sides had concluded, it was 12:47 in the afternoon. Judge Harmon took a recess of 40 minutes. When she returned, she delivered her ruling from the bench immediately. This was itself a signal to anyone in the room who understood the grammar of judicial decision-making. Immediate rulings in cases of this complexity communicate one thing: the record was clear. The charge of felony assault was reduced to misdemeanor battery, with credit for time served in pre-trial detention and a sentence of 12 months probation. The reduction was based on the self-defense evidence presented, the inconsistencies in the original investigative record, and the witness testimony regarding the sequence of events. Ethan stood at the defense table and listened to the ruling, and did not cry. He had learned, in 21 years and in the past several months specifically, that crying in rooms like this was something he did not allow himself. But something shifted in his posture. Something that had been held at a particular angle, sustained by a tension that was the physical expression of having been in a very difficult position for a very long time, released, incrementally, quietly. The way held things release when the holding is finally no longer necessary. Robert stood beside him. He did not put his arm around his son. He did not touch him. He stood beside him at the defense table and looked at the judge as she concluded the ruling. And when the gavel came down, he exhaled once, slowly, with the specific quality of a man releasing something he had been carrying for longer than 3 weeks. Dana Calloway put her face in her hands for exactly 4 seconds. Then she straightened, and she was composed again. The courtroom began clearing. In the movement and sound of this, Ethan and Robert stood at the defense table for a moment that was separate from the activity around them. Ethan looked at his father. Robert looked at his son. There were 5 years in the space between them, not the 5 years of the absence only, the 5 years of the return, of whatever came next, of the work of rebuilding something that is not the same as the thing that was lost, but that is real in its own right, if both people choose to make it real. That work had not started yet. It could not start in Courtroom 3 on a Thursday morning, with the bailiff resetting the room for the next proceeding, but it could start today, after this room, in whatever room came next. Ethan said, "How did you find the camera?" Robert said, "I knew where to look." A pause. "You should have looked sooner," Ethan said. "It was not an accusation delivered with heat. It was a statement of fact delivered with the specific flatness of someone who has processed a thing enough times that what remains is only the truth of it, clear and without additional weight." "Yes," Robert said. "I should have." They stood with that for a moment. Then Ethan picked up his copy of the ruling from the table and folded it and put it in the pocket of the orange jumpsuit he would be returning within the hour, and said, "I am going to need a ride." Robert said, "I have a car." They walked out of Courtroom 3 together. Not side by side exactly, not yet, but in the same direction, through the same door, into the hallway where Dana Calloway was waiting with her straight back and her composed face and the specific expression of a woman who has been holding something together for 5 years, and who is, for the first time in 5 years, considering the possibility that she might not have to hold it alone. Robert looked at her. She looked at him. The hallway was not the place for what needed to be said between them. But the hallway was what they had, and they were in it together. And that was further than they had been in 5 years. Ethan watched his parents look at each other. Then he looked at the exit at the end of the hall, at the light coming through the glass doors. The particular bright and indifferent light of a Thursday morning in Atlanta that does not adjust itself to the weight of what is happening beneath it, but that is there, regardless, available, falling on whoever walks through it without asking what they have been through to get there. He pushed the door open. He walked into it. The probation terms were met. The conviction, a misdemeanor and not the felony that had been charged, did not follow Ethan through job applications and housing applications and the invisible but structural ways that certain records close certain doors before anyone has opened them. He kept the job he had. He kept the apartment. He kept going to the community organization on Saturday mornings. Robert sent him a text 6 days after the hearing. It said, "I am in Atlanta through the end of the month, if you want to get coffee." Ethan read it on a Tuesday evening in his apartment. He sat with it for a while. Then he typed back, "Saturday works, morning." Robert replied, "Saturday morning." They met at a coffee shop 12 blocks from the courthouse on a Saturday morning in October when the Atlanta light had the particular gold of autumn in the south. And they sat across from each other at a small table and drank their coffee and talked. Not about the case. The case was closed. They talked about the years, both sets of them, the years of the absence and the years that had preceded it, with the careful and incomplete honesty of two people who understand that some conversations cannot be completed in a single sitting and who are deciding, together, whether they are willing to keep returning to it. They were there for 2 hours. When they left, they stood for a moment on the sidewalk in the October light. Robert said, "Same time next week?" Ethan looked at him, at the white hair, at the worn corners of the briefcase still in his hand, at the face of a man who was 61 years old and had 31 years of cases behind him, and one case he had handled too late, and who knew it, and who was standing on a corner in Atlanta, asking for a second chance in the only language available to people who know they do not deserve to ask. "Yeah," Ethan said, "same time." He turned and walked in the direction of his apartment. He did not look back, but he did not need to look back to know that his father was still standing there watching him go, in the particular way of someone who is learning, late and imperfectly, and with the full weight of the lateness. What it means to stay. To understand why Robert Calloway had been gone for 5 years, you have to understand what he had been before he left. Not the attorney. That part was clear in the record, in the Bar Association filings. In the case, histories that stretched back to 1993 when he passed the Georgia bar exam on the first attempt and joined a public defender's office in Savannah with the specific conviction of a 28-year-old who believes that what they are about to do matters and that their doing of it will make a difference. That conviction had been accurate. He had made a difference. He had made it case by case, year by year, in the slow accumulation of outcomes that does not announce itself, but that changes the specific texture of specific lives in ways that the people whose lives are changed carry with them long after the attorney has moved on to the next file. What you have to understand is what he had been as a father, and what he had been as a husband, and what had happened to both of those things in the particular way that things happen to people who are very good at one part of their life and who allow that part, gradually and without intending to consume the parts they have not thought carefully enough about preserving. Robert Calloway had been present for the first 10 years of Ethan's life, in the way that men who work 60 hours a week are present, intermittently, intensely when there, and occupying in their children's minds a space larger than their actual hours justify, because the quality of the presence when it occurred was real. He had coached Ethan's soccer team for 2 seasons. He had read to him every night he was home before Ethan was 8, and after 8 had switched to talking. Long conversations about whatever Ethan was interested in that week, conversations Robert had loved and that he had thought about during long drives between courthouses and that had represented in his private accounting of himself, evidence that he was doing the essential things correctly. He had not been doing the essential things correctly. He had been doing some of them correctly some of the time, and the gap between what he believed he was providing and what Ethan and Dana were actually experiencing had been widening for years, in ways that none of them had the vocabulary for until Dana finally found it. In a conversation on a Sunday morning when Ethan was 15 and his sister was 12, and the house was quiet in the specific way of a house that has been carrying tension long enough that the tension has become indistinguishable from the atmosphere, she had said, "I need you to be here in a way that you are not here." He had said, "I am here." She had said, "You are present. That is not the same thing." He had not understood the distinction she was drawing at the time. He had understood it as criticism and responded to it as criticism, which is to say, defensively, with a recitation of what he provided and what he did and the degree to which the life they had was built on the foundation of his work, all of which was accurate and none of which was the point. The conversation had not been resolved. Conversations of that kind rarely are in a single sitting. They return in different forms over the months and years that follow, and each return either moves them toward resolution or moves them further from it. And the direction depends on whether the people having them have developed, in the interval between returns, any capacity for the specific kind of hearing that the conversation requires. Robert had not developed that capacity. He had developed instead the capacity to manage the situation, which is a different and in many ways opposite skill. He had learned to produce the appearances of presence more consistently while remaining, in the ways that mattered most, as absent as before. And this had worked, in the way that managed situations work, until Ethan was 16 and something shifted in the boy that made the management visible for what it was. Ethan had stopped talking to him, not in the dramatic way of a teenager making a statement, not loudly or with declared grievance, but in the quiet and complete way of someone who has concluded that a particular kind of communication is not producing anything and who has redirected their attention accordingly. He answered questions. He was not rude. He was present at meals and family occasions with the cooperative minimalism of someone fulfilling an obligation, and he was otherwise in his room, or at school, or with his friends, and Robert had watched this happen, and had told himself it was normal adolescence, and had known, at some level below the telling, that it was not. He had left when Ethan was 16, not because of a single event and not in a dramatic way. He had taken a case in Washington that required his presence for 6 weeks, and then another, and then a position had been offered with a firm in D.C. that was doing the kind of constitutional work he had always wanted to do at the level he had always wanted to do it. And he had taken it, and the conversation about whether taking it was compatible with the life he had in Atlanta had not happened in the way it needed to happen, and he had told himself that the logistics would work themselves out, and they had not worked themselves out, and by the time he acknowledged this clearly, he had been in Washington for 7 months, and the distance had acquired a weight and a permanence that made it very difficult to move against. Dana had filed for divorce 14 months after he left. The divorce had been civil in the legal sense and not in any other sense, the way divorces are when both people are intelligent and neither person is willing to be wholly honest about their own portion of the failure. Ethan had been 17 by then, old enough to understand what was happening and too old for the kind of mediation that is available to younger children. Old enough to be left to his own conclusions, which were the conclusions you would arrive at if you were 17 and your father had been leaving for years before he actually left. Robert had tried to maintain contact. He had called. He had sent texts that received brief replies. He had come to Atlanta twice in the first year, visits that had the careful, managed quality of all managed situations and that had confirmed to Ethan, if confirmation was needed, that the management was the point and the presence was the performance. After the second visit, Ethan had stopped replying to texts promptly, and then had stopped replying to them within a week. And then the calls had gone to voicemail, and Robert had kept calling for a year, and then had called less, and then had stopped calling, and told himself that Ethan needed space, and that the space would eventually close. He had been telling himself this when Dana called. She had not called to ask for anything. She had called to tell him what was happening in the flat and informational register of a woman who has decided that the information should be transmitted because it concerns his son, and he is still the boy's father, regardless of what else he is or is not. She had told him about the charge and the arrest and the public defender and the hearing date. She had said, "I thought you should know." She had not said, "I need you." She had not said, "Come." She had said, "I thought you should know," and had waited to see what he did with the information. He had been in Atlanta within 48 hours. He had not called ahead. He had shown up at the house he had left, and Dana had opened the door and looked at him and said, "The hearing is in 3 weeks. He had said, "I know, I am going to need to work." She had let him in. He had not seen Ethan until the morning of the hearing. This had been Dana's decision, and he had not questioned it, because he understood, in the specific clarity available to someone who has spent 3 weeks doing the only concrete thing available to him, that he had not earned the right to question it, and that the question of whether he had earned anything at all was one he was going to have to hold without resolution for a long time, possibly forever, and that the correct response to this was not to stop, not to look for resolution before acting, but to act and let the resolution be whatever it was going to be. He had acted. The coffee shop on Saturday morning was not the end of that. It was the beginning of a process that had no guaranteed outcome and that required, from both of them, the specific willingness to keep showing up past the point where showing up is comfortable. Robert showed up. He was in Atlanta for the rest of October and all of November and into December. He found an apartment. He had not told anyone at the Washington firm what he was doing or for how long. He had simply rearranged his calendar and come south and been available on Saturday mornings and other mornings and evenings when Ethan texted to say he was around if Robert wanted to get food. The texts from Ethan came slowly at first. 1 every 2 weeks, then 1 a week, then sometimes 2 in a week. They were not long texts. They were the texts of someone who has not yet decided how much of themselves to give to a relationship they have been hurt by, which is to say, careful texts, specific texts, texts about concrete things rather than internal things, because concrete things can be assessed, and internal things are where the damage lives, and the damage is not ready to be in the room yet. Robert replied to all of them within an hour, not immediately, because immediate felt like need, and need felt like pressure, but within an hour, with the same specificity the texts had offered, meeting Ethan in the register Ethan had chosen, and not pushing for a different one. They ate dinner together in November, the 3 of them, Robert and Dana and Ethan's sister Maya, who was 18 and who had her own relationship to her father's absence, and who expressed this over the meal through a specific quality of watchfulness that Robert recognized as exactly the quality he had been receiving from Ethan for months, and that he understood as, "I am still deciding." He did not try to resolve the deciding. He ate his dinner and answered Maya's questions directly and let the evening be what it was, which was difficult and real and further than any of them had been 2 months ago. Ethan walked Robert to his car after dinner. It was a December night, cold for Atlanta, and they stood on the sidewalk outside Dana's house in the dark. Ethan said, "Maya thinks you're going to leave again." Robert said, "What do you think?" Ethan looked at the street. "I think you might. I think you might leave again because I think that's what you do. And I think I'm going to have to figure out how to have a relationship with you while also knowing that, and I don't know yet how to do that." Robert said, That's fair. Ethan said, "It's not about fair. I'm not interested in fair. I'm interested in whether you're actually going to be here." Robert said, "I don't know how to prove that except by being here." Ethan looked at him. "That's probably the most honest thing you've said to me in years." Robert said, "I know." They stood there for a moment. Then Ethan said, "Same time next week?" It was the question Robert had been asking. It was Ethan asking it now. Robert said, "Same time." And that was as close as it had come to resolution. Not closure, not the completion of a damaged thing, restored to its original form, but the beginning of a different form, built from what remained, which was two people with a shared history and a shared wound, and the willingness, fragile and real, to keep showing up to the Saturday morning coffee shop and eating the occasional dinner and texting about concrete things until the concrete things made room, slowly, for something less concrete. It was not the relationship it should have been. It was the relationship it was. And in the specific and imperfect arithmetic of second chances, that was enough to work with. Robert stayed in Atlanta. What Ethan Calloway had done with the 5 years of his father's absence was not what people who did not know him might have predicted. People who did not know him might have predicted a downward trajectory, the narrative of the fatherless son, the predictable arc of a young man without an anchor, drifting toward the kinds of choices that produce orange jumpsuits and courtrooms. This was not what happened. What happened was more complicated and more specific and ultimately more instructive about the nature of people than the predictable arc would have been. Ethan had worked. From the time he was 17 and old enough to hold a job legally, he had worked. First at a grocery store 3 blocks from the house, stocking shelves on weekend mornings and earning money that he divided with a precision that would have surprised most 17-year-olds. Between savings and contribution to the household expenses that he had noticed without being asked had become tighter since his father's departure. Dana had not asked him to contribute. He had started leaving money on the kitchen counter on the 1st of each month, in an envelope without ceremony or discussion, and Dana had found it and said nothing and used it, and when she finally mentioned it 2 months in, she had said only, "You do not have to do this." He had said, "I know." He had graduated high school with a GPA that his guidance counselor described as excellent, and that Ethan knew was the result of working harder than his classmates at things that came less naturally to him than they came to some of them. Because he was smart, but not in the specific way that produces effortless grades, and he had learned early that the gap between his natural ability and the grades he needed could be closed by time, and that time was something he was willing to spend. He had not gone to college. Not because college was unavailable to him in the abstract sense, but because the specific mathematics of his situation at 18 had not made it workable. Dana was managing, but managing and comfortable were different categories, and the scholarship he had been offered was partial, and the gap between the scholarship and the actual cost of attendance was a gap he could not close without debt that the numbers did not support. He had done the numbers carefully, the way he did most things, and the numbers had said, "Not yet." He had filed the application away. He had kept working. He had added a second job at 20, working weekend evenings at a restaurant where the tips were good and where the manager, a woman named Patricia, who had been running kitchens since she was 22, recognized in him the specific quality she called useful, which in her vocabulary meant shows up, does what needs doing, does not require management. She had promoted him to a supervisor role within a year. He had taken the promotion and the attendant responsibility and held it with the same seriousness he applied to everything. The community organization had come through a friend of a friend at 20. The friend had known someone who worked there and mentioned that they were looking for volunteers and that Ethan might be good at it given what the friend knew of him, which was that he was patient with younger people in a way that some older people are not. The patience not performative, but real, rooted in the specific quality of attention he gave to things. He had walked in on a Tuesday evening and met the director, a man named Carl Osei, who had been running the organization for 11 years, and who asked Ethan, in the first conversation, what he was good at. Ethan had said, "I'm good at figuring out what needs doing and doing it." Carl had said, "That is exactly what we need." He had been right. Ethan worked with teenagers between 15 and 19, the specific age range where the decisions that determine the shape of the next decade are made, and he worked with them in the way that was most useful, which was not the way of someone dispensing wisdom or providing a model to emulate, but the way of someone who sat next to them and looked at the actual problem in front of them and helped them think through it without telling them what to think. He was 20 and then 21, and working with 16-year-olds who reminded him of himself at 16, and what he gave them was not advice about his own choices, because his own choices were not the point. What he gave them was the quality of attention he wished had been given to him, the attention of someone who takes seriously the thing you are telling them without either minimizing it or making it larger than it is. The attention that says, "I hear this, I believe this is real. Now what do we do about it?" He had been doing this for a year when the night outside the bar happened. He had been coming out of a late shift at the restaurant. He had been walking to his car alone, late, and the two men who had decided that a young black man alone in the dark was a reasonable target had been wrong about several things. One of which was the degree to which Ethan Calloway was willing to be victimized without response. He had responded. The response had resulted in a fractured orbital bone for the man who had grabbed him first, and in his own arrest the following morning, when the man's friend, who had not sustained injury, had filed the police report that described the incident from a vantage point convenient to his friend's version of events. Ethan had told his public defender the truth. He always told the truth. It was not a moral stance in the performed sense, but a practical one. He had found, over 21 years, that managing multiple versions of reality required more cognitive energy than he was willing to spend, and that the truth, while sometimes costly at least, had the advantage of internal consistency. The truth was that he had defended himself from a physical attack. The truth was also that the defense had been effective, more effective than the attackers had expected. And the truth was that in the system that processed what followed, effectiveness in self-defense by a young man without resources against men who had a friend to file a police report was not a variable that automatically produced the correct outcome. He had not called his father. The thought had not occurred to him, not as a suppressed impulse, but as a genuinely absent one. His father was not in the category of people he thought of when he needed help. The category of people he thought of when he needed help was small and did not include people who had been absent for 5 years. His mother had called Robert, not to ask for help, she would not have said she was asking for help, but to inform, because informing was the correct thing to do. And Dana Calloway did the correct thing with the consistency of someone who has decided long ago that correctness is not optional, regardless of what it costs. What it had cost her was the call and the specific quality of not knowing what would happen after it, and the 48 hours before Robert showed up at the door, and the 3 weeks of watching someone she had once loved do the only concrete, useful thing he had ever been able to reliably do, which was work in the service of the child they had made together. She had let him in. She had made him coffee. She had not told him he was forgiven, because forgiveness was not something that happened in 3 weeks. And she was honest about what happened and what did not. But she had let him in. And she had made him coffee. And she had given him the information he needed to do the work. And she had watched him do it. She had cried for 4 seconds in the courtroom when the ruling came down. 4 seconds exactly, because that was how long she permitted herself. And then she had straightened, and she had been composed, and she had walked to the hallway and waited for her son, and the man who was still, technically, though not in any of the ways that mattered most, his father. The man who was learning, late, to be what he should have been all along. Jessica Tran filed her own motion the day after the hearing, not in the Ethan Calloway case, which was concluded, but in two other cases on her docket where she had found, in reviewing the investigation files with the specific attention Robert Calloway had modelled in court the previous day, the same pattern of incomplete investigative work, witnesses not interviewed, footage not sought, inconsistencies in the charging documents not pursued. She had always known these patterns existed. She had known them abstractly, the way you know things you have read about in law school and in the first year of practice, and that you understand intellectually without yet having seen them, with the precision of someone who has watched an experienced attorney dismantle one in real time. Piece by piece, documentation by documentation, with the patience and the specificity of someone who knew exactly where to look because they had spent 31 years learning where cases are lost and what it costs the people they are lost for. She called Robert 3 days after the hearing. She told him what she had found. She asked if he would be willing to consult. He said, "Send me the files." She sent them that evening. He read them overnight. He called her the following morning at 7:45, and they talked for an hour and 20 minutes about the cases, about the patterns, about what the patterns indicated about the investigative process in the jurisdiction and what could be done about it beyond the individual case level. He was direct and specific, and he listened when she talked, which she noticed because she was not accustomed to being listened to by senior attorneys in the way he listened, which was the listening of someone who believes the person speaking has something worth hearing. She asked him at the end of the call, "Why are you still in Atlanta?" He was quiet for a moment. He said, "I have reasons to be here." She said, "The cases or your son?" He said, "Both." She said, "That is a good answer." He worked with her on the 2 cases over the following 6 weeks. Both resulted in charge reductions similar to Ethan's, both based on evidence the original investigations had not gathered, and that Robert and Jessica found through the same methodical and patient process. Neither case got significant attention. They were the kind of outcomes that happen quietly, in the procedural machinery of a system that occasionally corrects itself when the right people are paying attention, and that are felt most significantly by the 2 people whose charges were reduced and who went home to their lives with a different set of constraints than they would have carried otherwise. Robert and Jessica wrote a memo. It described the investigative patterns they had identified across the 3 cases and proposed a set of procedural reforms for the Fulton County DA's office's review of charging documents in assault cases where the initial investigation was conducted without adequate witness canvassing or evidence collection. The memo was 4 pages long. They submitted it to the DA's office and to the Public Defender's office and to the court's Case Management Division, and did not wait to see what happened with it before moving on to the next case. Ethan heard about the memo from Dana, who heard about it from Jessica, who mentioned it in passing in a phone call about something else. He read it on a Thursday evening on his phone, sitting in the parking lot outside the community organization, after a late session with 2 17-year-olds who were navigating a situation that was not his story to tell, but that had required 3 hours of his attention and that he had given willingly, in the way he always gave attention, completely and without the performance of completeness. He read the memo twice. Then he texted his father. "I read the memo." Robert replied within 20 minutes. "What did you think?" Ethan typed back, "I think you should have been doing this a long time ago." A pause. Then, "You are right." Another pause. Then, "Saturday." Ethan looked at his phone. Outside the car window, the parking lot was quiet. The last of the session participants gone, the lights of the building warm and visible through the glass doors. He thought about the 2 17-year-olds he had spent 3 hours with. who were navigating something difficult with the particular courage of people who have not yet learned to be afraid of being wrong. He thought about what it meant to have someone in your corner who had showed up late and imperfectly, and who was nonetheless there in the corner doing the work. He typed back, "Saturday." He put the phone in his pocket. He sat in the parking lot for a moment in the quiet. Then he started the car and drove home. Stories like this exist in courtrooms and in the years before them and after them, in the long and imperfect work of return. If this moved you, share it, because the most important arrivals are rarely on time. But they are still arrivals. Subscribe for more stories the headlines miss, and in the years before them and after them, in the long and imperfect work of return. If this moved you, share it, because the most important arrivals are rarely on time, but they are still arrivals. Subscribe for more stories the headlines miss.